This is a question that comes up quite frequently. And the short answer is yes, but probably not the way you think. For example, your claim is denied. The workers' compensation insurer has denied primary liability. That means they're saying you didn't get hurt at work, or the facts of your injury are not compensable under Minnesota law. That's called a primary denial. Can you appeal that? Yes, but not the way you think. The appeal is you have to file a claim petition, and that's going to take 10 months to get to a hearing. You have to commence litigation, and you do that in the work comp system by filing a claim petition. So yes, that's an appeal, but you're not writing a letter to the insurer saying, hey, please reconsider my circumstances. In other cases, you might have an admitted injury. Say you slip and fall and you hurt your shoulder quite badly, and the workers' compensation insurer admits the injury. They pay benefits. They give you a QRC, a qualified rehabilitation consultant, to assist you, and they're paying for your treatment. And your doctor all of a sudden says, my goodness, you have a torn rotator cuff. You need surgery on this shoulder following an MRI. All of a sudden, the insurer goes, whoa, and they send you for an independent medical exam, and the independent medical examiner puts on their independent medical examination goggles, checks you out, and says, nah, you do have a torn rotator cuff, but it's not related to your work injury, or you don't need surgery for it. All of a sudden, you're facing a denial. And under those circumstances, again, can you appeal it? Well, if you're talking about writing a letter or sending an email or a text to the insurer saying, please reconsider, they're going to be like, no. We're standing on our denial. So at that point, that's where litigation commences. And again, you may have to file a claim petition, or you might have to file a rehabilitation request if it's a vocational issue, or you might have to file a medical request if it's a medical issue. It's going to depend. So yes, you can appeal a denial. The problem is that the workers' compensation system is complicated. And there are people who represent themselves, and that often isn't the best way to go. However, most people are not experts at the substantive law, and most people are not experts at the procedural law. There's a lot of procedural things that you want to be aware of on what is the best way to pursue a claim for benefits that have been cut off. For example, you might be receiving wage loss benefits, and the insurer just stops, and you're like, hello, and you can't get a response. Voicemail, email, text, you get no response. And you're thinking, what do I do? Well, the law says that the insurer is supposed to file what's called a notice of intention to discontinue your wage loss. Well, Dave, they didn't. What do I do? Well, the law says that within 40 days of your receipt of your last payment, that you can request a discontinuance conference at the Department of Labor and Industry. Well, it'll be set up at the Office of Administrative Hearings, but you can request a conference. Does the average layperson know that? Absolutely not. So again, can you appeal? Yes, the vehicle that you use, the way you do that is going to be really fact specific. It's going to depend. And that's why if you have a disputed work comp claim, you want to reach out to a good work comp attorney. And at Mottaz Sisk Injury Law, we are happy to answer your questions.